So, my name is Angelo Anzalone. I'm the president and founder of Veritas Legal Plan. In case you're wondering, the eye patch, it's not a fashion statement like one of those Michael Jackson hand.
But it's a cool patch, though.
It is pretty stylish. I was going to start with a couple of pirate jokes, but I thought that might come across a little too corny, so I decided against. With me today is Consumer Protection Attorney Jeffrey Lohman. I'd like to thank the AFCC board for the opportunity to speak today. We're excited to be here. We're excited to be here and have a chance to explain how. Teresa, what am I doing wrong here? Got it. How performance model settlement companies can stand above their competitors by offering full legal protection against lawsuits, earn additional revenue, as well as discuss the latest enhancements to the consumer protection monitoring service. For those who are not aware of who we are, Veritas offers a prepaid legal plan that was developed specifically to create a level playing field for performance model settlement companies. I've been in the debt settlement industry for, since 2007, when I started Active Debt Solutions. My fee structure was modeled after the Uniform Debt Management Services Act. I charged a $500 refundable deposit, $49 a month, and 25% savings. It was easy to sell because honestly at the time most companies were charging a lot more on the advance upfront fees, so it was fair. And anyone shopping around for a debt settlement program knew it was fair, and we did very well. But fair or not, 2010 put an end to my fee structure. We saw the creation of the attorney model, and we saw enrollments drop because consumers just hear the word attorney and they think all their legal issues are solved. That's when I saw an opportunity to create a product that provides not only a much needed service, but a level playing field, as well as an opportunity to earn additional revenue while staying compliant. My experience running a debt settlement program has made Veritas Legal Plan as successful as it is. I know the ins and outs of running a debt settlement company. I was successful because I understood the emotional stress that a consumer is going through while they're in a debt settlement program, especially when they receive a lawsuit or they just can't take those collection calls anymore. And for that reason, I created a plan that would provide two major legal services that most debt settlement companies deal with on a daily basis: lawsuit defense, collection calls. I'm going to spend a little time talking about the plan, explain the coverage and some of the benefits, and then I'm going to ask Attorney Lohman to go into specifics about the consumer protection, share some of his experience, bless you, and explain how the plan can help your members turn collection calls to cash. So when it comes to providing lawsuit defense, we have a process in place that ensures a smooth and comfortable experience for your members. We understand the emotional state that the member is in, so as soon as a lawsuit is submitted to us, our reps are on the phone with the client, letting them know that we've received the lawsuit, we're in the process of assigning an attorney, we walk them through what to expect next and answer any of their questions or their concerns. Members really appreciate this call. It calms them down, their anxiety is just alleviated, and they know that their issues are being taken care of. Once an attorney has accepted the case, the member is called again with instructions to contact the attorney to establish the relationship. The negotiator at the debt settlement company is also given the same information with instructions to contact the attorney to discuss a game plan based off of the member's ability to fund the settlement. Some members are going to have funds available for a settlement, others are going to need more time. Between motions and counter motions, I've seen lawsuits go on for over a year. Having time to accumulate funds to settle a lawsuit is probably one of the biggest advantages of the plan. And by the way, it's important to know that our attorneys are paid off of an itemized list of filings. So the more they do, the more they actually make. We strive to go above and beyond to incentivize our attorneys as much as we can, so they put as much effort in as possible. They don't simply file an answer and settle the account for full balance. Honestly, you guys don't need an attorney for that. You could do that on your own. We also reach out to the member and the assigned attorney 2 days before the answer is due, just for confirmation, making sure that everyone's on the same page and nothing slips through the cracks. We communicate and send reminders constantly. We don't just assign an attorney and walk away. I can't even begin to tell you how much members appreciate this communication and handholding. It really sets their mind at ease and it makes them feel safe. One of the other benefits of offering the plan that I always talk about is increased retention. And we all know that outside of a change in the member's financial situation, lawsuits and collection calls are the top reasons that consumers fall out of the settlement program. I've been told by many of our affiliates that they've seen an increase in their retention once they started offering the legal plan. And of course, to follow that bouncing ball, increased retention always means more settlements, happier clients, and of course, increased revenue. You're welcome. So to touch on our experience for a minute, when it comes to defending creditor lawsuits, in the last 5 years, we've provided and paid for attorneys to defend just over 3,600 creditor lawsuits. We've enrolled over 16,000 total members, and we have almost 300 participating attorneys in our network, with over 80 active affiliates offering the Veritas Legal Plan. Ask yourself, how do you stand out against a settlement company or a competitor that's offering lawsuit defense as well as a solution to the creditor calls? Many of our existing affiliates realized the need to compete and began offering Veritas once they lost a few enrollments to a settlement company that was able to offer the legal protection. Now, I talked about how offering the legal plan will increase retention, but you can also add a higher conversion rate to that list of benefits as well. The truth is, most consumers will speak to more than one settlement company when they're looking for a program. And offering lawsuit defense as a solution to the collection calls will always make you stand out above your competitors. And by the way, we can offer several customized options. Some affiliates have their own consumer protection program or other product that they offer their clients. They're only interested in providing the defense against creditor lawsuits. Some are looking to earn additional enrollment as well as residual revenue. Others don't want to make anything on it. They just want to provide the service to their clients. It's completely your choice, and we can offer volume discounts as well with prices as low as $12 a month. Now, when it comes to the consumer protection portion of the plan, I'm proud to say that our network of attorneys have won over 875 consumer protection violation claims with a minimum payout of $500, and in quite a few of those cases, the amount awarded was significantly higher, and the debt itself was wiped out entirely. Altogether, the consumer protection portion of the plan has resulted in a total payout of over $1.3 million in consumer protection violations.
Woo!
We are very proud of our accomplishments as well as the added value that Veritas brings to the debt settlement program. I felt the best and most credible way to explain how and why our consumer protection services are as successful as they are would be to have one of our top consumer protection attorneys speak about it. So at this time, I'm going to hand the mic over to Attorney Jeffrey Lohman. He's going to share his thoughts on the plan.
Hi, I am Jeff Lohman. I'm an attorney in Arizona. I've been practicing law for all of about 9 months. However, I've been in the industry for about 7 years, and during that time, I worked for a couple different law firms in assisting debt settlement clients build their FDCPA cases. Let me disclose that the statements I'm about to say are merely examples and are not guarantees. Also, for the attorneys in the audience, I make a lot of conclusory statements, so I do that because it's not a lecture on consumer protection laws. Since I've worked in the debt settlement industry, the industry and the companies within it have marketed themselves as being able to stop phone calls. We've always looked at phone calls as a problem, and I totally get it. Clients need help when they fall behind on their credit cards, and one of the client's greatest concerns is always dealing with phone calls. Phone calls are annoying, they're frustrating. Phone calls can even be embarrassing. No one wants to answer that call from an unknown number when they're with work or with friends. The debt settlement industry as a whole, at least in my experience, has offered one solution to this problem. As an industry, we've all helped to stop the phone calls. We've done this in many ways. Every company has its own way of doing it. Some companies send out cease and desist letters, at least until they realize that that related in more lawsuits. Some companies have their clients fill out the back of the credit card bill. I know some attorneys that send out notice of representation letters, and then others, like Veritas, have relied on the Google Voice number in providing clients with an alternate number that gets called. For the most part, we've done a pretty good job of stopping the phone calls. That is, unless your clients have payday loans, and those banks never stop calling. And I understand why our first instinct is to stop the calls. Falling behind on credit cards is an especially emotional experience. Our clients are embarrassed, they're angry, they're confused. I hear stories every day because no matter how many times I tell our clients I only deal with phone calls, They insist on telling me why they got into the situation that they did. We've all heard about lost jobs, sudden illnesses and medical bills. We've heard about lost husbands and wives and children. Just last week, I spoke with a 75-year-old woman who loaned her grandchildren money and they didn't pay her back. So she then couldn't pay her credit cards because all she has is Social Security. But in making the call stop, our industry's been missing out on a great opportunity to use the laws that are available to our consumers. Our clients have rights, and I feel like the vast majority of our clients in this industry are not aware of their rights. I know every debt settlement company has on their website the canned FTC explanation of the FDCPA, right? We all know a debt collector can't call their client before 8 a.m. or after 9 p.m. We know that the debt collector can't call them excessively, or they can't call them at work if they know they can't receive personal calls at work. I get all that. But how many of your clients know that if they get a message that says, "Hey John, this is Jeff regarding an important business matter," if that call is from a debt collector, it broke the law and your client's entitled to money? How many of your clients actually know that that broke the law? Or how many of your negotiators use that voice message to get your clients a better result? I don't think a lot. But even that knowledge isn't as powerful when compared to the knowledge of the TCPA. And again, I'm not here to give a lecture on the TCPA, but it's important to understand it. Because the work that we're doing at the Veritas Legal Plan through TCPA violations is really changing lives, at least 20% of the time. So the Telephone Communications Protection Act, I'm going to read this part, states that it shall be unlawful for any person to make any call using any automatic telephone dialing system to any telephone number assigned to a cellular telephone service. Really, it states that under the TCPA, a bank cannot call a client's cell phone after the client has asked them to stop. And there's case law out there that says the request can be done verbally. It doesn't have to be in writing. And unlike the FDCPA that has one monetary damage, up to $1,000, the TCPA's violations are $500 per call. So the violations add up a whole lot quicker and a whole lot more than just straight up FDCPA violations. Since September of last year, the Consumer Protection Department of the Veritas Legal Plan, we've changed our approach of how to help clients. Instead of the passive role, we've asked our clients to assume where we get the calls to stop by using a Google Voice number and then monitoring the messages for FDCPA violations. We've begun to ask our clients whether they're interested in taking a proactive role in getting out of debt. In this new system, we educate our clients on the protections afforded to them under the TCPA. So we start there. We then interview our clients to find out, where are they getting phone calls? Are the phone calls to cell phones? Are the phone calls to their home number? Are the phone calls to work? Where are the calls coming? Then we want to know what phone numbers are calling them so that we can identify what banks are calling our consumers. From there, we put the client on hold, we call the numbers, find out what the banks are, and then we talk to the client about what's really going on. If you're getting calls from these banks, this is what's going on. Are you interested in talking with the banks for just a few moments to revoke that permission of them calling your cell phones? Sometimes they say no, and then we just go back to the Google Voice number, and that's totally fine. We get the anxiety that these clients have. But most of the time, they choose to do the revocation. We have revocation specialists that then give our clients a script and then walk them through what's going to happen and prepare them for the call. We then connect them to the creditors to do the revocation. Once the revocation is done, we then transfer our clients back to the service representative that they spoke with, and that service representative works with them over the next couple of weeks to make sure that whether the calls are going in or whether the calls have stopped. 80% of the time the calls have stopped, but 20% of the time the calls keep going, and my department has the privilege of assisting these clients in building TCPA cases against their banks. These banks include original creditors, private student loan servicers, payday lenders, and car companies. Again, this is not a guarantee of service, it's just our average, but the average client will win or settle their claim for over $12,000. Now, I know all of you run your debt settlement models differently. I know it's pretty much performance, but some of you are performance-based, others are attorney models. And I know that regardless of the model you've chosen, you probably would be more successful if 20% of your clients came in with $12,000 available for you to use. Our consumer protection model increases your retention because your clients are related with our results. Our clients cry, what we call them with checks and money and all that great stuff. For those of you operating a performance-based model, our consumer protection model increases the speed at which you get paid. Again, if your clients came in with more money, if your client came in with $12,000 in the first 7 months, you'd have more money there to settle debts, you would earn your fees sooner. For those of you operating an attorney model, our consumer protection model supports your efforts in finding legal means to eliminate your client's debt. I'd also like to add that one of our attorney-based affiliates recently lowered their expected settlement percentage to 38%, based off of the effects that our TCPA cases had for their clients. So in closing, I'm not sure whether this presentation is supposed to sell you on the services offered by Veritas or just to highlight our successes within this industry, but I want to make sure that if you take only one thing away from just my few minutes, that you understand there's a better way to help clients than just stopping the phone calls. I think our way of assisting clients is absolutely the best, but even if you don't use our services, just know that there's a better way than just stopping the phone calls. Right now, I have a case, just as an example, in Texarkana, and I won't disclose anything, but the case is against Encore Receivable Management. I have no problem saying it because they wrote a newspaper article in the Texarkana Gazette about this case. They called her 295 times after 2 revocations. If we win this case, which I expect to, the client will receive over $100,000. Like, that's just one debt settlement client who will receive over $100,000. We're really changing lives in the way that we're helping consumers. And that's it. That's all I have to say. Thank you.
Thank you.
Thank you, Jeff. And to add to what Attorney Lohman just discussed, I'd like to also announce that we are deep into development into our consumer protection mobile app. It's going to work on both iPhone and Android phones, and once downloaded, this app is going to give the members the ability to record all inbound and outbound collection calls, take photos of collection letters, select voice messages, and forward those voice messages, all of that correspondence, to a consumer protection attorney to review for potential violations. I'm really excited about this mobile app. Not only the additional value it's going to bring to the legal plan, but the additional value it's going to bring to the debt settlement programs as well.
When does that launch?
We anticipate the release by the end of third quarter.
Wow.
So I'm really excited about that. I'd like to also mention that while we do offer on-site training and implementation for new affiliates, we're also helping to train the industry with the certified Veritas content that's now included in the well-respected IAPDA certification training and course modules for debt-related professionals. And lastly, I'd like to also point out that going into our 6th year in business, we still have an A+ rating with the BBB. I'm almost done. I know you guys are anxious to hit that cocktail reception, so I'm going to wrap it up with this. Even if you feel you don't see enough lawsuits, or if you don't want to take away from your client's ability to accumulate, or you're offering another product, many of your competitors are now offering Veritas Legal Plan, and they're seeing an increase in enrollments, an increase in retention, and an increase in revenue. Mostly what I think holds some companies back would be mainly fear of change. Now, not only have you worked hard to build your business and your reputation over the years, you don't want a third party to come in and potentially risk your reputation. But you've also developed a system of processes and steps that you've obviously worked well for you. And the thought of making a change to your sales scripts, your negotiations, your customer service department, obviously a little bit overwhelming. While change is scary, I'm afraid it's necessary if you want to compete. So what I'd like to offer, because I know that I'm confident you'll feel a lot more comfortable offering Veritas once we walk you through step by step how we handle each of the legal services that we offer. I'm looking for an opportunity to earn, obviously, your trust and the business. So for new potentials, I'm offering to cover the cost of 2, 3 creditor lawsuits, whatever it takes to make you feel comfortable. The opportunity to see firsthand how everything works before making a decision and jumping in with both feet. I'd like to also provide access to our video portal so you can see what the members experience as they are enrolling. And once you're comfortable with the consumer protection enrollment process, I'm offering at no cost to provide the consumer protection services that Attorney Lohman discussed, dozen members, however many it takes to make you feel comfortable. No commitment, no obligation. If you're satisfied with if you're not satisfied with the way the lawsuits are handled, or the appreciation from your members when Attorney Lohman's office pursues a potential consumer protection violation, then we simply part and there's no harm done. That's it for me. I'm done. Stick a fork in me. We're going to be available at the bar for questions. First one's on me. Actually, they're all on me. Thanks, guys.